Hello, my name is William Pernik.
And my name is Alana Wilson.
Alana and I are criminal defense lawyers in California. And if you have been watching our videos, you must know that lawyers in our firm have a lot of opinions on many topics that affect people's rights, and we're not shy about sharing them. Today, Alana and I want to talk to you about a very interesting observation that we have made, which is how the expansion of police powers led to a disproportionate impact on people of color, who we often represent as our clients. Now, Alana, I know that you teach criminal law and criminal procedure in a law school in Santa Clara County. And so, can you share with our viewers how the idea behind this video came to be?
So I noticed that with every topic that I was teaching, there seemed to be an issue of racial disparities in the criminal justice system on nearly every topic that you learn in criminal procedure. And my students seemed to be very interested in this topic, and it was a point of much discussion in our class. So I thought it would be a good topic to bring to our video sessions.
And, for me, it's been at least 20 plus years since I've been in law school. So it was really interesting when you and I started chatting about these big ideas and big cases and kind of seminal concepts in Supreme Court jurisdiction to really take a bird's eye view at some of these doctrines, how they came to be. And I think once we started looking at it from that perspective and asking the question why, we saw certain patterns emerge. Isn't that right?
Yes, absolutely.
And so I guess what we want to talk about in this video are the three big concepts and how they shape what we see play out in our streets and our communities every day.
Yes, absolutely.
So with that, take us to number one, the stop and frisk.
Yes, so stop and frisk is a doctrine commonly taught in criminal procedure classes. I would say every criminal defense attorney is probably aware of the stop and frisk doctrine. It is first introduced in a 1968 case, Terry v. Ohio, in which Mr. Terry was stopped and frisked because the officer believed he might have a weapon on him after he was searching some windows, possibly going to commit a burglary. And so that's where the idea came from. However, the issue in today's society is that the stop and frisk doctrine is disproportionately applied to people of color rather than white people. So if a person of color is walking down the street, they might be more likely to be stopped and frisked at random by an officer who is claiming that they thought that that person had a weapon on them rather than a white person.
Now, what's really interesting is that when you look at studies that calculate the likelihood of a person of color actually having a weapon or other contraband on them versus a non-person of color, the results are really intriguing because it shows that basing your investigative ideas on stereotypes actually is not a very effective technique.
Yes, there's actually a New York study that occurred in 1999 where 50% of the population in New York at the time was a person of color. However, 84% of stops for stop and frisk were people of color. However, the result was that a person of color was less likely to have a weapon on them when stopped and frisked. So it was they're being disproportionately stopped and frisked while being less likely to actually produce that contraband.
And then not only were they less likely to actually have a weapon or drugs on them, they were significantly less likely. The numbers were really staggering. Now, Alana, just to give our viewers an idea of how disproportionate this policy was and how many people it affected, I believe the numbers were something along the lines of 4.5 million people that were stopped from 2004 and 2012, is it?
That is correct.
And so out of 4.5 million people that they stopped, more than 80%, 84% were people of color. That means Black and Latino males predominantly. Only remaining 16% of that 4.5 million were non-Black or Latino suspects. And yet, when you look at the Latino or Black suspects, they had half the likelihood statistically of actually having contraband on them.
That is correct.
So, if anything, what does this policy show?
I think it shows a possible implicit racial bias, meaning that the officer may not know that they have a bias against somebody due to their race, but they have an internal belief that this person may be more likely to possess a weapon based on the color of their skin. And the results show that that's just simply not true.
And on top of that, I would add that the results show that when officers use correct investigative techniques and they're actually basing their suspicion that a suspect may have contraband or may have a weapon on objective facts, they're much more effective because they're not discriminating against white people when they're conducting these stops and frisks. I think in those circumstances, they're probably using articulable facts that would lead an officer to believe that, this person is possessing a weapon, and therefore the results are much more effective. Now, Alana, obviously the stop and frisk has impacted millions of people of color, but that's hardly the only Supreme Court doctrine that authorized this massive expansion of police authority and with it disproportional impact on our communities. Let's talk about another big one, the automobile exception.
Yes, traffic stops. So under Wren v. United States, which is a 1996 U.S. Supreme Court case, law enforcement has the ability to stop an individual whom they believe has violated even the most minor of traffic laws. So this basically means that the police have the right to pull you over if they believe that you've committed a vehicle violation on the road. That's such as getting stopped for speeding, getting stopped for having an expired registration tag, things like that.
Or more ridiculously, having a ball hitch that partially obstructs the license plate, that the officer, who sometimes you wonder in court may have a visual impairment of some kind, but the officer will claim, well, I couldn't read that. I mean, there's almost 30,000 provisions in the California Vehicle Code alone, and any one of those violations authorizes an officer to conduct a traffic stop.
Yes, actually one of the most ridiculous ones that I know you and I have seen in court was somebody weaving within their own lane in a serpentine manner was the allegation. In my opinion, I didn't see what was dangerous about that driving pattern.
In fact, I remember the hearing. We had a video recording of this incident. The officer's mobile audio video recording system, the dash cam, captured it. And so when you look at the dash cam, the person was driving straight as an arrow. And then we're presenting this evidence in court. The officer is testifying, well, from my, perspective, I could see it a lot better. We're seeing it with a naked eye. And of course, the judge sides was the officer, and we were really worried that perhaps Her Honor had some difficulty seeing what everybody else in the courtroom could see.
And what's particularly concerning about that is I recall that specific case occurred in November, and it was at nighttime. The wind conditions were obviously higher in November than they would have been in the summertime. Wind conditions can move your car perhaps ever so slightly in your lane. I don't see how that's a traffic violation necessarily, but an officer can pull you over for something as silly as that.
And so officers are allowed to pull people over for any traffic violation. So the officer then can scan the inside of the vehicle. What's problematic about that is that under the plain view doctrine, if an officer is in a place where he or she is allowed to be, anything they observe that leads them to believe that there is another crime is fair game. So they can pull you over for a pretextual or BS reason. They interact with you briefly at the window. They can observe that perhaps you have some marijuana inside the car, that perhaps there is something sticking out under your seat. They can start asking you questions about some other investigation that they're really interested in pursuing on you, and the traffic stop is just an excuse or a pretext. And we know that this happens all the time, but affects people of color disproportionately.
Absolutely. You're more likely to be pulled over for a traffic violation if you are a person of color. However, this traffic stop is less likely to yield evidence of contraband if you are a person of color than if you are white. So it's similar to the stop and frisk doctrine, where a person of color is more likely to be a victim of this government intrusion, however, less likely to actually yield the results that the government claims to be searching for.
And Alana, when I'm listening to something like this, I see images that we have all witnessed of, news coverage where you will have somebody who perhaps is African American, who is afraid of a police encounter, who may see a police officer and freak out and start driving away, getting themselves in further trouble with the law when really there was not a rational basis for this in the beginning. So I think it's highly problematic when we allow our biases, implicit or expressed, to run unchecked, and when police enforcement actions disproportionately impact certain people in the community more than everyone else, you are creating this rift between different segments of our society that I think is really dangerous. I think it leads to traffic stops becoming points of very heightened fear or anxiety, in particular among African American. I think when you have police actions that disproportionately impact one segment of our society as opposed to the rest, what that creates, unfortunately, is that you will have people who are afraid of cops. That means that they're more likely to appear nervous, more likely to appear anxious, more likely to flee from the police, and police officers in turn will misinterpret that observation as evidence of some criminality that's feeding into their pre-existing cognitive biases. And so you are setting in motion a chain of events where out of nothing, horrific things happen. Somebody gets shot, somebody gets beaten, and then later on you realize that the person was running for no reason whatsoever. So if we don't identify these problems in our society, if we do not address them, we're going to continue to observe things that we have observed that led to significant divisions and civil unrest in our society, I think. And that leads me to a third area that I think you were really interested in talking about because of one case that received a lot of attention.
Yes, that would be the knock and announce doctrine. So what this doctrine states is that when the police come to your home for any possible investigation, if they have a warrant and they come to your home to execute that warrant, they do have to knock on your door, announce their presence, and then wait a reasonable period of time, presumably 15 to 20 seconds, before entering your home. And so there is this case, Hudson v. Michigan, which states that even if the officer violates the knock and announce doctrine, that's not necessarily enough to throw away evidence in the case, which is a big concern because that does give the government some ammo there to violate the knock and announce doctrine.
Because after all, if there are no consequences for the violation, why not violate?
Exactly. And so the most recent huge case where this does come up is Breonna Taylor. And this was a famous case that occurred, I believe in 2020, where she was with her boyfriend. It was 3 a.m, and the police entered their home suspecting the boyfriend of drug dealing. It turned out it was actually a different person that they were looking for. It was not the man who was with Breonna Taylor. And as a result, he believed that there was an intrusion in their home. He fired a shot at the officer. The officer fired a shot at the bed, shot Breonna Taylor, and she was murdered on that night.
So how do cases like this affect the perception that our clients have in the community?
I think there's a lot of fear, especially for people of color, that, the police may treat them as if they're criminals without any actual proof of that being the case. I think, this country is founded on the idea that you're innocent until proven guilty. And for people of color, they're often treated as they're guilty until proven innocent. And these doctrines, while they may objectively sound like a very rational, objective manner of approaching investigations, when actually applied in practice, they can often lead to these racial disparities where people of color are being targeted and are being mistreated by our government while still having that technically fall under the law.
And I think for me, the flip side of that is that you are a lot less likely to seek protection from the police if you are a person of color,
Absolutely.
if you are afraid of them, if you have become a victim of a crime and you need to summon law enforcement for aid, but you happen to be Black or you happen to be Latino. You may be afraid that somehow this is going to turn around and you're going to become a suspect. I mean, we've had cases where you and I represented clients who have been injured by the police officers in perhaps a mental health type of scenario where there is a mental health crisis. Family member calls the police. Our client happens to be a person of color. Police officers show up. They're completely unequipped to deal with the mental health emergency. They go into this extreme, let's subdue the suspect, overwhelm him with force, shout directions at the suspect, and if he or she doesn't comply, then by golly, we're going to take him into custody. And that leads to people being injured. And of course, that creates fear in their families, in their communities that, hey, if I'm in trouble, if I need to call the police, I better think twice about that because I don't want to get hurt. I don't want to be the suspect. I don't want my boy or my daughter to get injured.
Yeah, and I think there are lots of cases too, not just Breonna Taylor, for instance, George Floyd, that show police brutality is a huge concern for people of color in this country. So it's not just that you might get stopped by the police for something you didn't do, but there's a lot more fear of being harmed, of being unlawfully arrested. And then this doesn't even touch the iceberg of, the actual court system. There's also biases with the judges, the prosecution, the jury. So it's not just an issue with law enforcement, it is an issue throughout the criminal justice system. And it is a huge concern to have to explain to a client that, they could be treated unfairly simply because of their appearance.
I agree with that. I think this is something that I have struggled with personally for a very long period of time, and that's because in theory, on paper, we have laws that allow us to litigate, for example, unlawful detentions, unlawful seizures, unlawful searches. We can bring a motion under Section 1538.5, arguing that our clients' Fourth Amendment rights have been violated. But routinely, these motions are denied. It's extremely hard to prevail in these motions. It is, in my opinion, even harder to prevail in these motions when you represent a person of color.
So one of the cases that I found really compelling in law school that I actually hadn't planned to talk about today, but it is a very relevant and fascinating case to me, is McCleskey v. Kemp, which is a 1987 U.S. Supreme Court case.
A capital case, right?
Yes, it is a capital case, which means that the defendant in the case, who was black, was sentenced to the death penalty for the murder of a white victim. And what was very interesting and unique about this case is the social study called the Baldus study that was brought in during the litigation, which basically showed that an attorney has to tell a black defendant that they're more likely to be sentenced to the death penalty if they kill a white victim as opposed to a white defendant who kills a black victim. It was also more common that somebody would be sentenced to the death penalty for black-on-black crime as opposed to white-on-white crime, which essentially means that we as attorneys had to tell our clients, if you are a person of color, and especially a person of color with a white victim, you are more likely to receive a more serious sentence. And in that case, it was a death sentence because of the color of your skin.
And I think the idea that certain people get treated disproportionately doesn't just start in these very serious cases. The problem for me, as someone who has been dealing with criminal law and practicing criminal defense for now almost 20 years, is that it appears to permeate throughout our system of justice, starting with law enforcement and the lingo they use. I don't know if you've ever picked up on it, but in reading police reports or listening to police communications or dispatch, even the codes that our police officers use to designate certain types of suspect clearly reveal there is a certain degree of bias. For example, do you know what a suspect number 1 is? Black male adult. They designated BMA. You can see suspect number 1, BMA, in your police reports. Suspect number 2, of course, is HMA, Hispanic male adult. Mm-hmm. So if a police officer is trained in the academy, on the job, and has been doing this for years, that the number 1 suspect you look for is a black male adult, how do you think that affects objective fact-finding when they're investigating a crime and the first person they come upon is a black male adult or a Hispanic male adult? I think this is really problematic. I think that raises important questions of bias, which can be either expressed or implied. Now, let's talk about what that means. Everyone understands the idea, I think, of express bias. That's when somebody is racist. You don't like a certain person because that person belongs to a certain group. Maybe you don't like a person because they're black. You don't like the person because they're Latino. You don't like a person because they come from Poland. Whatever the case might be. That's express bias. You take actions based on your beliefs, which are obviously ones that are hostile to a particular group of people. And I think with express bias, we have made significant changes. We have evolved, we've identified it, and we know how to fight it a little bit better than we used to, 50, 60 years ago. But now we are discovering that there is a completely different type of bias that permeates our legal system. And that's something called implied bias, right?
Yes, implicit bias is less easily observable than explicit bias, but still can have significant impacts on the way somebody might be affected in the criminal justice system.
And so what is implicit bias?
So I would say implicit bias is similar to what you were referring to earlier, where a person may have seen a pattern that has led to their beliefs without actually recognizing that they're having those beliefs. So for instance, an officer may be more likely to stop Latino people in a certain community because they'd had to go to that area in the past, but they didn't actually intentionally pull over people of that group with the idea that they were being racist. They just internalized some racism based on their own experiences, perhaps.
And tragically, this does not just affect the police officers, but also support personnel in their offices, forensic folks who might be conducting investigation, even lawyers and judges, right?
Absolutely. It runs through the entire system. So it's not just an issue on the streets with law enforcement, it's an issue throughout the system.
And one of the things that have been happening in California recently is a series of reforms that are now introducing the idea of bias training throughout the legal profession. Lawyers like you and I are required now to go through a certain number of hours every single year so that we can learn to recognize implicit bias within us, within others, learn how to address it, combat it, and the same thing applies to judges who have to go through the same type of training. But then we also have this new law that was passed in California, something called the RJA, or Racial Justice Act. Can you tell us a little bit about that?
Yes, so the Racial Justice Act was enacted in 2020 with the intention of combating explicit and implicit bias in the racial justice system. So what it allows for is that now criminal defendants, or those who have been impacted by possible bias within the system, can now appeal a conviction if they believe that this conviction was the result of perceived racial bias.
And what's really interesting about that is that the RJA goes beyond just allegation that somebody was intentionally racist towards them, but it actually allows statistical analysis of, let's say, a particular district attorney's office. You can take a look and see how many people of certain group have been chosen to be prosecuted a certain way, how many whites versus non-whites get charged with certain crimes. And that allows you to identify bias that exists within the system that even well-meaning members of the legal profession may not themselves be aware of.
Yeah, definitely. It's something that can happen at any level, and this act is great because it allows for defendants to combat that bias that, could have a significant impact on their lives. So yes, that is correct. It is a huge concern because it can affect at any stage of the criminal procedure. And what's great about the Racial Justice Act is that it does allow for these individuals to seek relief no matter where the implicit or explicit bias occurred.
And I think the particularly important part of that is the implicit part, because obviously there will be bad apples in every agency. It could be in police department, it could be in the district attorney's office, it could be in the investigative service, it could be in public defender's office, whatever. There will always be someone who is a bad apple, who doesn't belong in the chosen profession. But the recognition of implicit bias is really significant because now you can conduct statistical analysis and see, for example, what charging decisions are made on a global basis against the particular whites versus blacks versus Latinos get charged with certain crimes. And in these cases, even if there is not an intent to discriminate against a particular group, the numbers can show that there might be something happening beneath the surface that reveals a problem that could hopefully be corrected or fixed.
Absolutely, yeah. So the problem might not always be visible at the surface, but that doesn't mean that the problem doesn't exist. So it's great that this act does address that.
In conclusion, what we wanted to tell you is that over the last 50 or 60 years, our society have gone through significant changes. Unfortunately, we also have a number of legal doctrines that dramatically expanded the scope of police powers. Because of biases that exist in our society, some actual biases and some implicit biases that hide beneath the surface, these expanded police powers resulted in significantly disproportionate impact on those of our clients and members of our community who are persons of color. In California, there is a process to recognize that this is happening and correct it through something known as the Racial Justice Act. However, this must be a national effort which every state will join in order to train and rewire all members of the legal profession, all members of law enforcement, to recognize things that might be happening beneath the surface, to recognize those biases that enter their minds subconsciously, and to change the way we interact with other people on the streets, in our courts, in order to increase access to justice and increase fair and just legal outcomes. And until that happens, we unfortunately will continue to have divisions in our society, we will continue to have civil unrest, and we will continue to have certain people in our society afraid of the police as opposed to asking police for help. So if you care about fairness, if you care about justice, if you do not want to turn on your TV and see another story about a black person or a Latino man or woman being beaten, being harassed, running away from the police, you should care about these issues, because if we implement these changes, the hope is that we're going to dramatically decrease the incidence of these types of encounters. We really hope you enjoyed this video. Alana and I really care about talking to our viewers about issues that interest us as lawyers. We really don't want to see any more injustice in our society. We don't want to turn on the television and see another story of a person who does not belong in a criminal justice system getting arrested after running from the police out of fear and for no good legal reason. We want to see our society change and evolve and recognize that there are reasons that are hidden from us that govern our behavior. And hopefully, with additional recognition and training on implicit bias and how it affects all of us, including law enforcement and members of the legal profession, we can achieve that. So if you enjoyed this video, please click like, please subscribe, and stay out of trouble.